Alonzo Martinez, Associate General Counsel at HireRight, and this is Navigating Compliance, the first webinar in our 2023 Quarterly Update Series. While I'm a lawyer, today's webinar is not intended as legal or compliance advice. My intentions are to give you information that you'll take as talking points to raise with your teams and with your legal counsel. Before we begin, I want to cover a few housekeeping items. During this webinar, please take the conversation to Twitter using the hashtag HireRightWebinar. In order to receive HRCI or SHRM credit, you must attend the full live session of this webinar. Credit information will be emailed a few days after the webinar. We are not providing copies of today's slides. However, we will send you an email with a link to a recording of this webinar session. If you are experiencing any audio or video issues, please refresh the browser window by clicking F5 on your keyboard, or send us a message using the Q&A icon at the bottom of your screen. Rich is producing today's webinar and will be monitoring the feed for any issues. After the presentation, we would appreciate getting your feedback. Please take our brief survey and let us know if this session was helpful. My focus is to create sessions that are meaningful, so we welcome ideas for future topics. So take 60 seconds out of your day and let us know what you think. And again, please press F5 on your keyboard to refresh this presentation anytime you experience any audio or video problems. I've been characterizing legislation introduced in 2023 as bills that do more with less. What we've seen is lawmakers really pushing legislation that has broader impact and generally supports workers' rights at the expense of additional compliance obligations for employers. And that's really what we're going to talk about today. So with our theme of doing more with less, you'll see clean slate laws usurping down the box measures, pay transparency trumping pay equity, and continued progression in the marijuana space. So there is today's rundown on the screen. I'm going to provide an overview of the current state of the law, a snapshot of legislation that we're monitoring, and most importantly, I'll offer some practical guidance to comply or prepare to comply with those laws that we cover today. So as usual, we have a lot of ground to cover today, and I'm going to try and keep a quick pace through these topics. So please do not consider this to be a comprehensive discussion, but it should provide you with a good overview. And I'm always looking for new opportunities to create content that is beneficial for you. So when you fill out the survey, let me know what you'd like me to focus on in future webinars. So as always, settle in for the next hour. And remember, if you have any questions during this webinar, use the Q&A icon, and I'll try and cover those at the end. So we are going to kick things off today with a broad discussion concerning criminal history reform. And here is a look at clean slate laws across the United States. So what are clean slate laws? Well, clean slate laws expunge or seal some criminal records from the public view once someone remains crime-free for a period of time. 1 in 3 Americans has a criminal record, and in many cases, criminal convictions can be a barrier to employment. So the purpose of clean slate laws is to remove the stigma associated with criminal history so that individuals who have offended have an easier time of getting a job. And as you can see on the screen, every state except for Wisconsin offers some form of post-conviction expungement of sealing or expunging criminal offenses to various degrees, and that's what you see on the screen. In case you're wondering, if you're over the age of 25 and were convicted of a crime in Wisconsin, you have to petition the governor for a pardon for post-conviction relief, but that conviction still stays on your record. So Wisconsin is lagging behind with respect to clean slate, but they do offer some level of an avenue of relief for ex-offenders. Looking at the rest of the United States, you'll see states that wipe the slate clean of most nonviolent felony and misdemeanor convictions in red, some felonies and misdemeanors in blue, misdemeanors and pardon felonies in green, misdemeanors only in yellow, and only specific offenses as directed by state statute in orange. That's Alaska, Florida, and Hawaii. So again, the takeaway is that in most states, there's some form of post-conviction relief that wipes a nonviolent criminal record clean so that qualifying offenses no longer appear on a court's records. And if they don't appear on a court's records, they won't be reported in a criminal background check. So that is the impact of clean slate laws. And what I've done for you is create this map to show you the states that offer automatic relief to ex-offenders. This means that qualifying offenses are automatically expunged or sealed from a court's records. And you can see the various types of offenses available for automatic relief in the legend of the map. So generally, all nonviolent convictions and non-convictions are those in the red color. In orange, you have the most restrictive of expungement or sealing cases, and that's generally non-convictions only. And in the gray states, an individual needs to petition the court to have any qualifying criminal history sealed or expunged. It's not automatic in those gray states. And obviously, automatic expungement or sealing is most advantageous to an ex-offender. It's automatic, right? You don't have to do anything. Many ex-offenders in gray states where a petition needs to be filed may be intimidated by the process of sealing or expunging those offenses, and they may feel the need to engage a lawyer, which obviously costs money. But the good news is that there are numerous organizations that can help get them through the process. But what we're ultimately looking for with respect to clean slate laws is automatic expungement. And here is an overview of clean slate laws that were passed or will become effective in 2023. I've listed these in alphabetical order for you, starting with Arizona on the left side of the screen. I'm going to just hit a few highlights. At the end of 2022, Arizona enacted a petition-based process to seal or expunge misdemeanor and most felony convictions. This year, the law was amended to clarify that a person is not entitled to a second chance if they've previously had a felony conviction set aside. This means that the conviction still exists on the person's records, but the penalties associated with the conviction have been released. That's what set aside means. So if we think about that, there is a bit of a limitation with respect to Arizona's clean slate law. Moving on to California's expanded clean slate law, California leads the country in criminal history reform by extending automatic and petition-based and record relief to felony level offenses after only 4 years. This is very different from other states where there is a longer period of time generally towards this automatic or petition-based record relief. So in California, automatic expungement becomes available for most defendants convicted of a felony on or after January 1st, 2005, if they have completed their sentence and any remaining parole and probation and have not been convicted of a new felony offense for 4 years. So again, the most expansive clean slate law in the country. Continuing on to Idaho, next year, individuals with relatively minor nonviolent, non-sexual offenses may petition to seal their public records so long as they have gone at least 5 years since the completion of the sentence without any subsequent offenses. And in Utah, most nonviolent misdemeanors are automatically expunged if the offender goes 5 to 10 years without another conviction, depending on the level of the misdemeanor or the felony conviction. Virginia amended its laws to provide for automatic relief for dismissed cases and some misdemeanors and allow for petition-based sealing for a number of misdemeanor and felony convictions. And last on the screen is Washington, D.C.'s petition-based clean slate law. Sealing by petition is available for all non-conviction records and for misdemeanor convictions and most felonies after waiting periods of 5 and 8 years after the completion of the associated sentences. So that's what we've seen in 2023 with respect to state-level clean slate laws. I've received a lot of questions concerning Connecticut's new clean slate law, so I want to spend just 1 minute to provide some clarification. Under Connecticut's new clean slate law, certain types of criminal convictions will be automatically cleared from a person's record after a certain amount of time has passed. So that's what you see within the left sidebar. And here is our point of clarification. Connecticut requires that employers who ask their candidates to self-disclose criminal history, those candidates need to be provided with a notice, which is what you see in the center of the screen. To be perfectly clear, and this is where I've received some questions, the text of the notice has not changed because of the new clean slate law. I just want to bring awareness of the need to provide that notice if you require that candidates self-disclose their criminal history. So again, it's incumbent that you review and revise your self-disclosure notices if you ask candidates in Connecticut to self-disclose their criminal history. No changes to the notice. If you already have that notice in place, you don't need to change it. If you do not have that notice in place, you should implement it. But in general, it's really important to review any self-disclosure notices, as well as the questions you provide to your candidates to ensure that they are compliant and relevant to your screening program. I would be remiss if I didn't cover ban the box and fair chance jurisdictions. Here is a look at the landscape of ban-the-box jurisdictions impacting private employers at the state and local levels. Again, private employers, not public employers like government institutions, counties, or states, for example, but private employers. So in all 39 of the jurisdictions on the screen, you can't ask the "have you ever been convicted of a crime" question until some later time in the hiring process. In the 19 jurisdictions you see on the screen in red text, the ban-the-box measure applies to any form of work for monetary gain. So if you pay somebody to do a job, then they're subject to the ban-the-box measure. So that would include not only your traditional employees, but also contractors. This is often something that is missed by employers, for example, in the gig economy space, or those of you who hire perhaps day laborers. If you hire independent contractors, they are also subject to the ban-the-box law if they are in a jurisdiction that is in red text. If you've attended my previous webinars, you know that I always say not all ban-the-box laws are created equal. In all ban-the-box jurisdictions, you generally cannot ask the candidate if they've ever been convicted of a crime during the initial application or request a criminal background check. So those are the jurisdictions in the gray standard box. But then there are also some jurisdictions that require special handling. On your screen, you'll see those in the aqua column that require that you identify the criminal conduct that may disqualify a candidate from hire and provide them with that notice as part of the pre-adverse action process. There are those in the blue column that require that you conduct and provide an individualized assessment that relates the candidate's criminal conduct to their job as part of the pre-adverse action process. And in Los Angeles and New York City, shown in the wine-colored column on your screen, you also need to provide additional city-provided notices or, quote, substantially similar forms as part of the pre-adverse action process. So again, the city makes those notices available. You can use those notices, or you can use substantially similar forms as part of the pre-adverse action process in LA and New York City. And then there are some outlier jurisdictions. These are a little strange. 4 jurisdictions: Louisiana, New York, Atlanta, Georgia, and Gainesville, Florida. Those 4 jurisdictions do not specifically ban the box, but they do require that you conduct an individualized assessment. Again, an individualized assessment is your analysis of the candidate's criminal history and its potential relationship to the position for which they are under consideration. While you have to perform the analysis, you don't necessarily need to provide it to the candidate. Now, the EEOC, the Equal Employment Opportunity Commission, their 2012 guidance to employers and the use of arrest and conviction records is a good read that can help you understand the individualized assessment process if you are unfamiliar with it. And we have linked to that in the resources section of this webinar. So check out that resources section, and you should find the EEOC's 2012 guidance to employers. So in a nutshell, you can't adopt a one-size-fits-all model for compliance. You're going to have to modify your adjudication and pre-adverse and adverse action practices to align with a particular jurisdiction's law. So with that said, I always like to offer a quick reminder to HireRight clients that you can use our Compliance Workbench solution to manage your ban-the-box obligations. The solution's made available to you for free, so let us know if you want more information when you fill out the survey. And a quick plug: in January, we published new ban-the-box white papers, as well as a new ban-the-box, or actually a new sample pre-adverse and adverse action template for your reference. So you'll find both documents if you are HireRight clients within Compliance Central, which you can find in Screening Manager. If you are not a HireRight client, but you would like our ban-the-box white paper, you can find that in the HireRight Resource Library. Just do a web search for HireRight Resource Library, take you there, and you can find our ban-the-box white paper. So let's shift gears and talk about legislation that we're monitoring, starting in California, where the California Civil Rights Department, the CRD, they released proposed modifications to the regulations under the Fair Employment and Housing Act, the FEA, that address an employer's consideration of criminal history information in employment decisions. While there are several changes proposed by the CRD, I want to focus on clarifications regarding the individualized assessment process. Again, this is the process that you would undergo whenever you are assessing a candidate's criminal history relative to the job to which they've applied. So the CRD gave us some examples of the considerations an employer can take as part of the individualized assessment process. And they also gave us a description of the types of evidence that an employer may want to consider when conducting the assessment. Those are the points raised in the second bullet on the screen. So looking at that, these are things like how the candidate spent their time while incarcerated. While they were incarcerated, did they make use of their time to engage in positive endeavors like work or school? Or did they simply do their time? And then what did they do post-incarceration? Did they get a job? Did they engage in positive social activities like joining clubs or civic organizations? So once published, one substantive impact on you as employers is that as you conduct criminal screening of California residents or workers, and as you conduct those individualized assessments, which are currently required under California law, you will need to undergo more fulsome, more thorough individualized assessments against these new standards, and you'll need to document those. The CRD's proposed revisions do contain many other possible impacts to you as employers. For example, there are additional requirements if you use work opportunity tax credits or WOTC. So again, if you conduct criminal screening in California, it's worth taking a look into the revised Fair Employment and Housing Act. Again, I think we've linked to that in this webinar in the resources section. So take a look at that. And let's move forward. And say in California, I realize that to now the discussion may seem very California-centric, but it is the largest economy in the United States at $3.5 trillion and the fifth largest economy in the world. So I think the discussion's warranted. So just stick with me for another minute or two. Let's talk legislation and briefly cover two bills, one that's helpful to employers and one that I would categorize as incredibly problematic. So let's start with the good news, if we will, and that is SB 647. So let me provide a little bit of a backstory, and then we'll talk about SB 647. In 2021, a California court decision held that certain personally identifiable information maintained in court indexes has to be held private. As a result, information used to match a criminal record to an individual, these are things like date of birth, are no longer available to background check companies. And if we can't conclusively match a record to an individual, we obviously cannot report that record to you as employers per the FCRA and relevant other laws. So the result of this court decision is significant delays in processing criminal check requests. Well, in 2022, the California legislature passed SB 1262, which would have restored access to personal identifiers. But things didn't go so well. In a move that surprised many, including myself, California Governor Newsom vetoed that bill, leaving employers high and dry when trying to protect their workplaces and their clients or patrons by using criminal background checks. So now we have this new bill. We have SB 647. It was introduced by Senator Stephen Bradford out of Los Angeles to require the clerk of the Superior Court to allow access to public information that identifies criminal defendants, and it would permit the clerk of the court to audit persons who have access to public record information. More specifically, the bill requires certification that the public records information is required for the preparation of a background report by a consumer reporting agency, a background check firm, and that the person who is the subject of the report has consented to the preparation of the background report. So this bill, if passed, would be immensely helpful to employers and candidates in California, as we, background check firms, would be able to more easily match criminal records to individuals, which would in turn reduce turnaround times. So SB 647 is very important legislation that has been introduced by Senator Bradford. And now for the bad news, and that is SB 809. On February 17th, SB 809 was introduced by Senators Smallwood Cuevas and Senator Wahab, and the impact to employers is significant. If SB 809 is passed, most employers would be prohibited from conducting criminal background checks in California. Again, if SB 809 is passed, most employers would be prohibited from conducting criminal background checks in California. Only those subject to a federal or state law that requires that an employer consider a candidate's criminal conviction history would be able to do so, and an individual could only be disqualified from a position after an individualized assessment is conducted, and there is some relevance shown to the law federal or state law or regulation that requires that criminal check be conducted. So the bottom line is that SB 809 will prevent most of you from conducting criminal background checks. So this is obviously a gap that you would have in your processes to assess risk to your organization. So as we wrap on our California conversation, as you complete the survey following today's webinar, please let me know if you would be interested in advocating in favor of SB 647, restoring data bird access to public records, or in opposition of SB 809, which would prohibit criminal background checks. Again, if you're interested in advocating in favor or in opposition of these bills, we'll pass along any advocacy opportunities that flow down from our industry organization, the Professional Background Screening Association, PBSA, so that we can make sure that your voice is heard. And a quick note for those of you in the banking or financial services industry who are regulated by FDIC Section 19, just a few substantive highlights. The fair hiring and banking provisions note that a waiver from the FDC is no longer required if it has been 7 or more years since the offense occurred, or if an individual was incarcerated with respect to the offense, and it has been 5 or more years since the individual was released from incarceration. Remember that you have to pay attention to certain barrier crimes for employment if you are FDIC regulated. So under these new regulations, you only have to consider the previous 7 years of criminal history. An individual is also not barred from employment for any conduct occurring before the age of 21, and if it has been at least 30 months since the sentencing. So if they committed crimes that would be barrier crimes before the age of 21 and at least 30 months have passed since the date of sentencing, they are no longer barred from employment. Additionally, the scope of de minimis offenses, these are very minimal offenses as well, has also been expanded to include many issues that the FDIC now considers low risk. So the good news to employers in the financial services industry is that you now have a bigger talent pool as the barriers to employment have been reduced. And practically speaking, if you've historically relied on criminal search depths that exceed 7 years, for example, many of you choose a 10-year period or perhaps an unlimited period of criminal convictions reporting, you no longer need to search beyond that 7-year period. So again, if you're currently choosing 10 years or unlimited variable searches because of FDIC Section 19, you're going to likely want to revise the criminal search depths to 7 years within your screening packages or accounts. So that is updates regarding the financial services industry. So as we recap, I always try and bring you some actionable guidance as we navigate the compliance landscape. So as a reminder, if you ask candidates to self-disclose their criminal history, you should periodically review your questions and any state or local instructions or notices that apply to your candidates. It's your responsibility as employers to ensure that those notices and questions are compliant and relevant for your screening programs. Just a reminder to make sure that you're familiar with the laws that are relevant to the special notices or assessments that are required to ban the job with respect to ban-the-box jurisdictions. So you want to make sure that you've established those processes to comply with those specialized notices or assessments in ban-the-box jurisdictions. And again, if you're a HireRight client, you can manage those processes in Compliance Workbench or outside our platform if you prefer. Like we covered, things in California are a mess. We could use your support in favor of a bill that would restore public access to personal identifiers and public records, and in opposition of a bill that would prohibit criminal background checks. So please let us know if you're interested in having your voice heard by lawmakers. And if you are in the financial services industry and are regulated by FDIC Section 19, you'll probably want to revise the scope of your criminal screening packages so that you're only considering information within criminal information occurring within the last 7 years. So as we close out our criminal history reform section, I want to remind you to get your questions in using the Q&A icon at the bottom of the screen. Let's pivot and test your knowledge. If you've attended my previous webinars, you know that I love audience engagement. So what I'm going to do is walk you through a fact pattern, and then I'm going to ask you to decide the case. This one deals with FCRA, or Fair Credit Reporting Act compliance. As a reminder, the FCRA is the statute, the federal regulation that regulates the background check process at the federal level for both employers and for consumer reporting agencies, background check firms that provide you with background checks. So here are the facts, which you'll see on the screen. Our plaintiff applied for a job with a company that operates in the logistics, supply chain, and transportation space in California. As part of the hiring process, the company provided the candidate with a background check disclosure and authorization form. The disclosure language read as follows, and you'll see that on the screen. By signing below, you hereby authorize the company to procure reports on your background as described above from any third party or consumer reporting agency contracted by the company. The plaintiff signed the disclosure and then sued the company, asserting that the disclosures violated the FCRA. Specifically, the plaintiff argued that the disclosures, 1, were not clear and conspicuous, and 2, were not contained in a standalone document as required by the Fair Credit Reporting Act. Before I ask you to decide the case, I'm going to give you a little more context. The plaintiff took issue in particular with the phrases third party or consumer reporting agency and the company, which you see in the disclosure. And the plaintiff said that those terms, third party consumer reporting agency and the company, were confusing. He also took issue with the fact that this company, the logistics company, sent him the same disclosure twice. So he argued that he didn't get a, quote, conspicuous disclosure as required by the FCRA. Finally, he said that certain elements on the disclosure, like the company's logo, their trademark, navigation buttons on their online form, and an FAQ hyperlink were extraneous information, that they violated the FCRA because they were something that was more than what is required in a background check disclosure. So here is your chance to decide the matter at hand. Did the company's disclosure violate the FCRA? Was using generic text like the company confusing? How about including an FAQ within the disclosure? Did that violate the requirement that the plaintiff be provided with a standalone document? I'll give you a few seconds to get your answer in. All right, in 3, 2, and 1. And here is the answer to the poll. It looks like a split decision. Interesting. All right, well, let's talk about why the court decided as they did. Well, the logistics company actually moved for summary judgments. So they essentially asserted that the claims against them were baseless, and the court agreed. So the court didn't actually have to hear the case. They decided that there was no merit to this case. The court found that because the candidate applied for a position with the logistics company, a person could reasonably infer that the company referred to the prospective employer, the logistics company. So the court found that the disclosure was clear. They also didn't take issue with the fact that the prospective employer supplied the same disclosure to the candidate on 2 different occasions, nor did they find that the links, the navigational text, the company's logo, or phrases concerning the scope of the check, including the FAQs, were extraneous or otherwise violative of the FCRA's standalone disclosure requirement. So there you have it. I think that this is some really good points of reference for you to consider as you review your disclosure and authorization documents with your legal counsel to ensure compliance with the law. Again, review your disclosure and authorization documents periodically. Keep abreast of any of these cases to make sure that you are updating your disclosures and authorizations as required, so that you don't fall into a trap where you're providing non-compliant disclosures to your plaintiff. So let's keep things moving. Just a quick note: a revised FCRA summary of rights has been issued by the Consumer Financial Protection Bureau, the CFPB. The changes to the FCRA summary of rights are minimal. They basically update contact information for a variety of federal agencies. There's no substantive updates, but we do need to be mindful that there is a new summary of rights. As a reminder, employers need to provide the FCRA summary of rights along with a copy of the background report as part of the pre-adverse action process. In the event that you may disqualify an individual from hire or affected workers' employment based in whole or in part on the results of a background check. So again, you have to provide a copy of the FCRA summary of rights and a copy of the report anytime you may disqualify an individual from hire. The new FCRA Summary of Rights must be in place by March 20th, 2024. If you're a HireRight customer, we're currently undergoing a change management exercise and we'll have the revised document in place well in advance of the 2024 enforcement date. But if you manage the pre-adverse and adverse action process outside of the HireRight platform, or if you're not a HireRight client, please ensure that you update your processes to include the new FCRA Summary of Rights by March 2024. All right, so we are tracking along. Let's shift gears and talk about pay equity measures. Remember that pay equity measures look to promote equal pay for equal work and will often include a ban on asking a candidate about their former compensation until some later point in the hiring process. And here is a map I created to show you the jurisdictions that require that you either post or provide a salary range for any open positions. The concept of pay transparency is exactly that. It requires that employers are open about how they pay their employees. This means that you need to conduct a pay analysis by each role to determine the minimum and maximum ranges for those roles and share the pay range within any job posts or advertisement. Again, you have to do that for any of the jurisdictions that you see on the screen. And here is a table that breaks down pay transparency laws that were passed or will become effective in 2023. In California, employers with 15 or more employees are required to post the minimum and maximum pay scale for any job within the state. Rhode Island has a wage transparency and pay equity law that became effective at the start of the year that also requires disclosure of benefits. And at the bottom of the screen, you'll see an amendment to Washington's equal pay law. The amendment requires employers with 15 or more employees to disclose the wage scale or salary range of job postings, along with a general description of benefits to be offered. Let's talk about New York. There is a flurry of wage transparency activity in New York. Let's start by covering kind of our general basics. All the measures on the screen note that an employer and their agents cannot advertise a job, promotion, or transfer opportunity without disclosing the compensation or a range of compensation for the position. That is our baseline for all laws in New York. Let's talk about some specifics. You might remember that the state of New York enacted a wage transparency law, and the scope of the law, especially as it related to remote workers, was unclear. Well, recent amendments tell us that the pay transparency law is applicable to remote workers anywhere who report to an individual like a supervisor in New York or who are assigned to an office in New York for reporting purposes. So again, if a remote worker is assigned to a manager or supervisor in New York, or if for reporting purposes they're assigned to a New York office, then they are in scope of the New York law. So again, that really clarifies the scope of remote workers. If there's any entanglement to New York, the New York law applies. Let's talk about some pay transparency nuances at the local level. You'll see that Albany County's law became effective in March, and like Ithaca's law, it requires 4 or more employees within either Albany County or Ithaca within those respective jurisdictions. The applicability of the law to remote workers, however, is unclear in either of those ordinances. New York City was the first jurisdiction in the state to pass a wage transparency law, which became effective on November 1st, 2022. Concerning remote workers, the pay disclosure requirement doesn't apply to positions that cannot or will not be performed, at least in part, in New York City. So let's unpack that. If a position could be filled by a candidate who resides in New York City, then an advertised position for remote work must disclose a pay range. So again, to the extent that you would consider any candidate within New York City, you would have to disclose a pay range. The same is true for Westchester County, whose law became effective as of November 6th. One note, though, let's circle back to the New York City law. The New York City Council is considering amendments to the law, which would require publication of job descriptions in all job advertisements, as well as benefits and any non-wage compensation. It's unclear if or when this bill might pass, but if it does, it would become effective 180 days after its passage. So again, this is one we're going to have to continue to monitor, because you may need to start including benefits as well as non-wage compensation, as well as job descriptions within your disclosures to New York City candidates, again, remote workers, would be included if a job could be performed in New York City. So those are our updates out of the Empire State. I wanted to clue you into two bills that are being considered by Congress, which would require salary transparency and enact a salary history ban at the federal level. So those are HR 1599 and 1600. In summary, employers would be required to post pay ranges for all internal and external positions and would be prohibited from inquiring into or relying on former compensation to set future compensation. Take a look at the penalties. Stiff penalties for violations are contemplated by both bills. So again, we'll keep monitoring this for you, and we'll provide you with updates should either 1599 or 1600 pass. And here are pay equity or transparency bills that we're seeing proposed at the state level. I've identified a few bills that I consider notable on the right side of the screen, including Colorado's bill that would amend the existing pay equity bill to require the employer to provide specific information to employees regarding the candidates selected for the opportunity and disclose the requirements for career progression and the terms of compensation, benefits, status, duties, and access to further advancement. So this is a huge change in Colorado, right? And I think a huge change for employers in general. You would basically need to disclose why you selected the candidate that you selected. And then you would also need to tell future employee or current employees what they need to do specifically to advance their careers in the future, as well as disclose any compensation, benefits, or other sorts of non-wage compensation available to them in the future. Really, really big change. In Connecticut, that's the third bullet on the screen. Employers would need to disclose pay ranges by position, including benefits to workers annually. Annual disclosures of compensation. So potentially big changes on the horizon for employers, especially in Connecticut and in Colorado. So as we wrap our pay equity and transparency discussion, remember to assess your policies and procedures to comply with pay transparency laws. Remember to conduct an internal pay equity analysis and assess how you are paying individuals by role and race and sex, and then you can work to remediate those pay discrepancies. Most importantly, rethink how you post jobs. If you need to post minimum and maximum salaries for all positions, could you? And even if a jurisdiction hasn't passed a law that requires salary transparency, should you move forward with adopting salary transparency in advance of those laws? I spoke with one of our major clients in the retail space who employs individuals at a national level, and they've decided holistically to disclose all salaries for all positions. So that's a consideration for many of you that are multi-state employers. And then I want to circle back to that bill that's under consideration in Colorado. Many states modeled their pay equity legislation after Colorado's. If you had to be transparent with respect to your hiring criteria, could you do that? Maybe it's something to consider as you review and revise your hiring process. So that is our pay equity and transparency discussion. Again, use the Q&A icon at the bottom of the screen to submit your questions. Moving right along to privacy, tech, and employment. Let's start with a recap of our state privacy laws. This is state privacy legislation. Iowa is newest to our list of states. There are six states listed on our slide here. The important takeaways for employers are that each of these laws basically require that individuals are notified concerning the collection, use, and retention of their data, and that they're given some control over the data. Now, here is the good news. Each law contains an exception for activities conducted in compliance with the Fair Credit Reporting Act. So that means that background checks, when conducted under the Fair Credit Reporting Act, are out of scope for all state privacy laws. So again, any data collected for the purposes of processing the background check request is outside of the scope of each of the privacy laws you see on the screen. But in certain states, specifically California, other employee data may fall into scope. Let me know if you have any questions about that as we start to get into our Q&A session. So here is a map of state privacy legislation that we're tracking. The states in red are modeled after Virginia's privacy law, which is generally accepted as the best balance of consumer protections against the needs of businesses and employers. Those in aqua have some Virginia language, but also include more restrictive terms. And those in blue are outliers. They don't follow the Virginia model. I should also mention that Indiana's privacy bill has been passed by both chambers and is being sent to the governor for signature. So expect Indiana to be the seventh state to pass a privacy measure in the United States. Let's move on and look beyond state privacy laws towards laws impacting the use of artificial intelligence in employment. Starting with New York City's law, which prohibits employers from using automated employment decision tools, or AEDTs, to screen candidates or employees unless a bias audit has been conducted prior to deploying the AEDT. The law requires that employers using automated employment decision tools undergo an annual bias audit on the AEDT conducted by an independent auditor and publish that information to their website. There's also a notice requirement. Employers have to provide notice to the candidate 10 days prior to the use of an automated employment decision tool in the hiring process. So for most of you, that notice requirement would be publication on your website that you are going to use AEDTs as part of the employment selection process or decisioning process for your candidates or employees. The New York City Department of Consumer and Worker Protection, or the DCWP, recently published final rules concerning the city's AI law. The rules provide clarity on gaps within New York and its AI law. In brief, an employer first has to figure out if the tool that they're using is an AEDT. To really simplify things, an automated employment decision tool is some sort of computer-based solution that substantially assists or replaces discretionary decision-making concerning employment issues. So if you use a tool or a solution to help you decide, for example, who gets an interview, who gets a job, who keeps their job, any sort of employment-related decision, if this is computer-based and it either assists you or replaces your decision-making, then, and you are an employer in New York City, then you're likely subject to the New York City AI law, also known as Local Law 144. As I've already mentioned, there are audit, publication, and notice requirements. There is a very short runway to compliance. New York City's Local Law 144 will be enforced effective July 5th, 2023. It is already in effect. It will be enforced in July. I've included the city's full overview of the rules associated with this law in the resources section of this webinar. So again, take a look at that resources section. And if you have any questions concerning this particular law or any AI and employment law, let me know using the Q&A icon at the bottom of the screen. And here is a look at the states that are considering legislation that would restrict an employer's use of automated employment decision tools. Those are the states in red. And in blue are states that have introduced legislation to form task forces to assess the impact of artificial intelligence in employment decisions. These task forces would ultimately be the task forces responsible for helping propagate laws to regulate AI and automated employment decisions. Let's keep things moving. Before we wrap our privacy, technology, and employment section, let's talk about what's going on in California, where lawmakers and regulators are approaching the concept of AI and employment decisions from multiple angles. I've covered 3 of these on the screen, starting with the first bullet. In addition to several clarifications concerning the definitions of artificial intelligence and machine learning, I think what's particularly helpful is that the rules being proposed clarify how an employer can defend against claims of disparate treatment or adverse impacts on a class of employees or candidates concerning an automated employment decision. So basically, an employer can demonstrate that the criteria used to make an automated employment decision is job-related and consistent with a business necessity, and that there are no less discriminatory ways to serve the employer's interests in a manner that is as effective as the artificial intelligence or machine learning tool. So that's what we have with respect to defending claims of bias, basically saying that there are no less restrictive ways from a job-related position, and it is consistent with business necessity. Then there is Assembly Bill 331, which is similar to the New York City AED2 law, that's Local Law 144 that we just covered. There would be audit and notice requirements for employers that use automated employment decision tools. And then finally, Senate Bill 721, which forms an exploratory group to assess the use of AI and AEDTs in employment. So that is the three-pronged approach to be what is being considered in California. We're, of course, going to continue to monitor this as everything takes hold. So as we recap, let's navigate the compliance roadmap. FCRA regulated background check data is exempt from the scope of state privacy laws, so you don't need to concern yourself with, for example, a data protection agreement with your background check vendor for that data. However, if you operate in California, you'll need to assess your ability to comply with that state's privacy law as it relates to other employee data. For example, the personally identifiable data that you collect as part of the application or interview process. Additionally, you want to ensure that you are transparent concerning your use of artificial intelligence. For example, when using AI solutions that automatically filter out resumes or who determine who gets a job. And if you operate in New York City, assess your use of automated employment decision tools and prepare to comply with the law, which will be enforced on July 5th. And know that there are several other AI and automated employment decision tool laws on the horizon. Again, please ask any questions using the Q&A icon. And we will move right into our cannabis reform discussion. You're going to hear me use the terms cannabis and marijuana interchangeably in this section. They are the same thing. Again, cannabis and marijuana are the exact same thing, so please do not let that confuse you. Here is our medical cannabis map available in the resource library and in our cannabis ebook. Looking at your screen, you'll see states in blue where accommodation is likely not required, states in aqua where anti-discrimination measures are in place and where accommodation is required, states in yellow where the regulation is silent, and states in white that haven't passed a medical cannabis law. When I talk about cannabis accommodation, I mean that in certain states you cannot discriminate against an individual just because they are a lawful marijuana user. And of course, the need to accommodate not only differs by state, but also by position. For example, there are typically but not always exceptions to accommodation for individuals in certain safety-sensitive positions. And there are always exceptions for those in DOT-regulated positions. And you'll see Philadelphia identified by the orange dot. Pennsylvania has a medical marijuana law, and in Philadelphia, marijuana testing is banned from most positions. So just a reminder to ensure that you are not testing most workers in Philly for marijuana. Again, testing workers for marijuana in Philadelphia is banned for most positions, so you want to make sure you remove that from your panels. You may have noticed that new to our list and our map is Kentucky, that passed a medical marijuana law earlier this year. Kentucky's law does not require that employers permit or otherwise accommodate its use, so you can test for marijuana, and you can adversely impact the employment of anyone who tests positive based on current law. You can also prohibit a registered user of medical marijuana from performing in safety-sensitive roles. And you can contractually prohibit vendors from assigning workers to you who use medical marijuana. So a lot of protections for employers in Kentucky. Kentucky's law will become effective by January 1st, 2024, after implementing rules are established by the state. Keeping things moving, here is our recreational map. As you can see on the screen, all states and cities in aqua, blue, or purple have legalized recreational cannabis, also known as adult use legalization. While locations in aqua have no impact on employers, those jurisdictions in blue or purple are different. Those jurisdictions shown in purple allow for pre-employment testing for marijuana. The statutes say that an employer cannot impact employment due to a positive test for THC. So again, you can't impact somebody who tests positive. And New York State has prohibited pre-employment testing for cannabis unless an exception applies. So unless an exception applies, you cannot test for cannabis for any candidate in the state of New York. So again, please make sure that you've aligned your drug testing panels accordingly. This isn't something that is automatically done for you. It requires your direction, since some of your positions may be exempt from the prohibition on testing. Again, let us know if you need some help with this when you complete the survey at the end of the webinar. We can help you align your drug testing panels. So let's run through upcoming new or amended recreational marijuana laws. Again, I'm just going to focus on highlights that may drive drug screening program changes for you. Starting in July of 2020, employers will be prohibited from discriminating against workers who use marijuana while off duty and off premises, and will prohibit employers from adversely affecting the employment of a worker who tests positive for, quote, non-psychoactive cannabis metabolites. So Psychoactive metabolites are those that make some people feel high. Non-psychoactive metabolites don't make a person feel high. They don't indicate impairment. They only indicate that cannabis was recently used. The law does not impact an employer's ability to deny marijuana users who are in certain safety-sensitive roles or other federally regulated jobs. So how do you test for psychoactive metabolites? I reviewed this with our chief medical officer, and he has recommended oral fluid as a screening option. So as you are considering your drug testing policies and processes for California's law, you may consider moving to oral fluid screening if you find that testing for THC is important for you. In Maryland, this summer, adults will be able to lawfully use recreational marijuana. As a reminder, medical marijuana is already legal in the state. However, neither Maryland's medical nor recreational marijuana laws provide any employment protection for users. So there's no real impact to you as employers in Maryland. Let's wrap our discussion with a review of Washington, D.C.'s Cannabis Employment Protections Amendment Act of 2022. Big changes coming if you are an employer in D.C. Employers would not or are not able to adversely affect an individual's employment based on their use of medical marijuana or the presence of THC metabolites in any drug test without any, quote, additional factors indicating impairment. So again, broad protections for all users of marijuana. And while you don't need to remove THC from your testing panels, you may choose to do so in order to comply with DC's law. Moving on. Sorry, we've got some lag here. And here is a map that shows all recreational, medical, and combination recreational and medical laws under consideration, and also an expansion of existing laws in Illinois and Washington. There's way too much to cover here considering we are running a little short in time, but I did write a piece about this that was published at Forbes and on the HireRight blog. I believe we've linked to that in this webinar in the resources section. So let's quickly move through our actionable guidance summary in case you missed it. I'll lead by saying that it is impractical to maintain zero tolerance drug policies. Instead, employers should focus on cannabis use and impairment work and ensure that policies are amended to reflect that position. It's also really important to adjust your policies and practices so that if a drug test is positive for marijuana, you understand whether that individual is a medical recreational user. And in some cases, you may have to accommodate the medical use of marijuana, but not the recreational use. And in some jurisdictions like New York, you must accommodate all marijuana use, period. Finally, remember to revise your drug testing panels to exclude marijuana where required for most jobs. Again, this isn't something that we as your drug screening provider is going to do for you because we don't know if a candidate you're considering for work may work in a position where marijuana testing is eligible or where you have to exclude somebody who tests positive for marijuana. So again, it's your responsibility, but we can help you adjust those panels. So let us know if you need help adjusting any of those drug testing panels when you complete the survey at the end of today's webinar. And just to reiterate, any jurisdiction that has passed a law legalizing marijuana, either for medical or recreational use, always exempts DOT regulated positions serving a federal contract or subject to federal funding, and in many cases, safety sensitive positions as defined by that particular jurisdiction statute. So that is everything that I have on marijuana and cannabis. I hope I have helped to clear the air a little bit. If not, get your questions in using the Q&A icon at the bottom of the screen. Now let's breeze through a few updates concerning the I-9 process. I'm just going to hit the highlights to bring awareness to these issues. The current virtual remote process for completing an I-9 that was implemented because of the pandemic has been extended through July 31st, 2023. Recently, DHS announced that it was accepting public comments to consider alternates to the in-person I-9 completion process that existed pre-pandemic. So could the virtual remote process potentially be a permanent solution offered by DHS? Maybe. Let's just stay tuned for more on that avenue. There are also several new combinations of acceptable documents that are approved for use. Those are the load documents. Check out DHS's website for more information. And finally, there is new green card. There's a new green card design, which I want to show you next. So on the left is the new design. You can see changes from the old design on the right. Both the documents on the left and on the right are still acceptable, but I wanted to show you the new green card so that you can know that you can accept it as part of the I-9 process when you see it. The new cards began being issued at the start of January, so some of you may have already seen them. But again, both cards are valid. Expect to see the new cards as they roll out. So here is our recap. You can continue to use the virtual I-9 completion process through July. There are new load combinations available to you, and you'll start to see a new green card circulating, but that doesn't invalidate the old design as long as the old card isn't expired. Again, we've linked to several resources in this webinar, so you may want to go to that resource section in the webinar, bookmark those, or copy and paste them into an email and refer to them in the future. I can also include them in a blog piece. So here is a quick plug as you get your questions in for our Q&A session. We have several outlets of information for you to consume. So if something piqued your interest, please check out our resources library, our blog, and our Forbes articles to learn more. In our last 5 minutes or so, let's dive into our Q&A. And I should mention that all of the Q&A, all of the questions received today will be consolidated and turned into a blog post that you'll find at the HireRight blog in just a few weeks. So if I don't get to your question today and it's pressing, please let me know when you complete your survey and I'll get back to you more quickly. Otherwise, expect to find your question asked as part of a blog. That is our You Asked, We've Answered blog series. So let's get into some of those Q&As. And we have a lot of engagement. More than 60 questions. So questions regarding the clean slate process and in general, how it affects the background check process. So again, many states have passed clean slate laws. The clean slate laws effectively, they're intended to remove a particular criminal conviction or a criminal charge from the public indexes. The public indexes are basically what you can search when you go to a courthouse. So certain states provide for automatic expungement. That means the candidate doesn't have to do anything. Qualifying crimes are automatically removed. Other states require that a candidate petition to have those particular crimes removed. I'm going to just talk about Connecticut really quickly because Connecticut is one of those states that has an automatic expungement law, which means that as of the start of the year, certain crimes should have begun falling off of the public indexes. Just a quick note, Connecticut hasn't quite been able to deliver on what they promised. Specifically, there have been technological challenges, which means that some of these crimes are still remaining on an individual's record. So from a background check perspective, we as a consumer reporting agency are effectively going to search for whatever is within the public index and report whatever is made available to us. Because again, qualified crimes should be expunged, but we don't know if, for example, an individual has committed another crime or if for some reason a court hasn't expunged that crime. So to that end, we're going to continue to report any qualifying crimes that are reported to us or made available in the public index. If those crimes have been sealed or expunged, they will not be made available. Another question regarding the self-disclosure notice in Connecticut. Again, that self-disclosure notice has not changed. So if you've had that self-disclosure notice in place, you do not need to revise it. If you're not currently asking candidates to, to self-disclose their criminal history but have not updated are not providing that notice, you need to do so. So again, take a look at your questions and the notices that you provide to candidates and make sure that they are compliant and relevant for your screening program. From a pay equity perspective, questions regarding salary history and salary history bands. Yes, you can always ask a candidate what their salary expectations are in any jurisdiction that has banned asking candidates about their previous salary history. Okay. Questions about the pre-adverse and adverse action process as it relates to ban the box jurisdictions. So there are standard pre-adverse and adverse action notices, then there are modified pre-adverse and adverse action notices that relate to a ban the box particular requirements. So for example, if a jurisdiction requires an individualized assessment, or that you notify a candidate of the potentially disqualifying criminal conduct, you would need to then conduct that individualized assessment and in many cases include that individualized assessment as part of the pre-adverse action process. So the candidate knows why you're making the decision that you're making. Similarly, if a jurisdiction requires that you identify the potentially discriminating criminal conduct, you would need to know that so the candidate understands why they are being disqualified for that, potentially being disqualified for that particular position. So again, you would do that within Compliance Workbench if you're a HireRight client, or outside of our platform if you are not. So with that, we are just about out of time. You can expect this webinar to be posted to the HireRight resource library shortly. You'll also receive an email with your SHRM and HRCI credit in just a few days. So with that, I'd like to thank you all for your time today. So again, please take 60 seconds to complete the webinar survey. I take your feedback seriously. You know, many of you I followed up with personally. So please let me know how I'm doing. This is my report card. With that, we're going to chat again in the summer, which will be our mid-year update. I'll cover all of the laws that have been passed over the legislative season that impact your employment screening program. Until then, thanks again for spending a portion of your day with me today, and we'll meet again in the next quarter. Thanks again, everyone.